Mr. Trush, what's the first case that you're ready?
Well, we're ready on Mr. Butts, and he is present. We're ready on Mr. Roll, but I think we got to get him pulled up on Polycom because he is Hodge.
All right, Mr. Butts, if you come up to the podium, please. We'll go on the record in People versus William Butts. This is file number 246743. If I could have counsel put your appearances on.
For the record, John, my photograph people.
Thank you, Your Honor. Richard Church, appearing on behalf of Mr. Butts.
Mr. Trush, how did you want to proceed on this file today?
Thank you, Your Honor. I believe we do have a resolution of this file. So we would be resolving this. Mr. Butts would be admitting to a single count of simple assault. The remainder of this complaint would be dismissed. Just so the court is also aware, we do anticipate, I think there's a misdemeanor file in the district court that we anticipate we're going to be resolving as well. And in addition to that, there is a violation in Crawford County, which we anticipate we're going to be resolving in a similar fashion. Hopefully this afternoon, if Your Honor will hear.
Okay, so he's just going to plead to count two in the information.
I believe that's correct. Yes.
Mr. Rolla, is that a correct statement?
It is with some modification. It's not an anticipate in the other file. It would be the defendant entering guilty to domestic violence in file 2443441 SM3. In other words, it's both of them, not at a matter of some point in time at a later date.
Okay, so this part of this agreement is that there's a guilty plea entered in the other case.
Correct, Judge.
And if for some reason it's not, then this goes away.
And this plea is withdrawn.
Mr. Truch, is that correct?
That is correct, Your Honor.
Okay.
And I believe we're up on the 27th in front of Judge Hesselink where we would anticipate that.
Okay. Mr. Butts, have you had an adequate opportunity to speak to Mr. Truch about this agreement?
I have, Your Honor.
Is that how you wanted to proceed today?
Yes, sir.
Raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. Lower your hand. I'm just going to ask that you have your hands out. Yeah, not in your pockets. That's
Oh, no, they're
yeah.
right up here.
Okay, I thought you had.
No, sir.
But okay.
Nope.
I do that with everybody. It's not
No, that's okay. No, I just had them on the podium.
All right, Mr. Butts, do you understand that the maximum possible penalty then that you could face for count two, which is assault or assault and battery, is a misdemeanor of up to 93 days and or a $500 fine? I understand that.
Sir.
And then, as we've indicated here, you understand that part of this agreement is that you're also going to plead guilty in that district court file, and I have no idea what potential penalties may be there. Do you understand that?
Yes, sir.
Are you otherwise, and you're on probation, right?
Correct.
And you understand that this could be a violation of your probation.
Yes, sir.
And you could face additional penalties in that case as well for pleading guilty here.
Absolutely.
With all of those things in mind, what is your plea to that charge here today?
Guilty.
So right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial, to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand that you have all those rights?
Yes, sir.
You understand that by pleading guilty here today, you're going to be giving up and waiving all of those rights, including the right to have a trial.
Correct.
Has anybody threatened you with anything to get you to plead guilty?
Sure.
Has anyone promised you anything other than what we've said here in court today?
No, sir.
Is it your own free choice to enter this plea?
Yes, sir.
Are you pleading guilty because you are in fact guilty?
Yes, sir.
This happened back on June 18th of 2024. Is that the correct date?
I believe so, yeah.
Okay. And on that date, did you have an altercation with someone named, I'm not sure how to pronounce the first name, last name is Edson?
Yes, sir. Yes, sir.
So, did that happen somewhere here in Otsego County?
Yeah, down at the Otsego there by the old Gobblers.
Okay. The Timberley?
Yes, sir.
Okay. And did you have some kind of physical altercation with that person?
Things got heated between me and her boyfriend, and she interfered, and I pushed her out of the way, and I put my hand on her.
Okay, and you weren't doing that in self-defense?
No, sir.
Mr. Rolla, are you satisfied with the factual basis?
Yes, Judge, thank you.
Mr. Trush?
Yes, Your Honor.
Mr. Rolla, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
None by the people, thank you.
Mr. Trush?
I'm aware of none.
Mr. Rolla, are the people satisfied that the court has complied with statute, court rule, and taken this plea?
Yes, Your Honor.
Mr. Trush?
I am satisfied.
Mr. Butts, the court finds your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. I am going to set this for a sentencing hearing at a separate date. You'll be notified of the date and time of that hearing. Ms. Davis, if I could just have a misdemeanor report, just really just outlining the facts of what happened during this incident. So better versed in the circumstances. And then make sure that you stay in touch with Mr. Trush before that sentencing date.
Can we get an updated address for him? It looks like mail came back.
Do you have an updated address?
Should be 6078 White House Trail, Vanderbilt, Michigan, 49795. It might have been because of the last snowfall. I didn't get out to the shovel to mailbox in time.
Okay. Was that the one that did that?
Yeah, but I think that they have it as Gaylord, so I'll get that fixed to Vanderbilt.
Oh. Okay, thank you. That's all. All right, sir, is your name Christopher Roll?
Yes, it is.
Okay.
Right in the middle of the screen.
Okay, we'll go on the record now in people versus Christopher Roll. This is file number 256812 and 256813. The record should reflect Mr. Roll is present today by video from the Otsego County Jail. If I could have counsel for your appearances now.
Thank you for the rest of my grown up.
Thank you, Your Honor. Richard Trush, appearing on behalf of Mr.
Thank you. Mr. Trush, can you tell me how to proceed in this file today?
Yes, Your Honor. So this is our first hearing up here in Circuit Court. Mr. Roll is currently in the jail on a probation violation on his district court file. We're not ready to resolve this just yet. We do have an offer from the prosecutor. Again, it's not completely clear to me if we're going to take advantage of that or not. I would suggest to the court maybe 30 to 60 days would be appropriate for us to come back and have a decision made.
Okay, Mr. Rolla.
The offer was extended back on March 12th. We have no objection to one more adjournment to hopefully resolve this matter short of trial.
Mr. Trush, are you anticipating that there's resolution of an encompass both files?
Yes, the offer that was made does,
Encompasses both
yeah,
files.
it is a global resolution.
Okay. Is there anything that you're waiting on, discovery or otherwise, that would take longer than 30 days?
I don't believe so.
Okay. Is there any other reason why you think your client wouldn't be ready to make a decision about a plea offer in 30 days as opposed to 60?
I think the only consideration that I would ask the court to look at is, again, he's incarcerated right now. We anticipate that if he takes advantage of this plea deal, there's likely to be another period of incarceration. So I think some period of time for him to get things in order is likely going to be important for him.
So I'm going to set this for a plea hearing status conference in 60 days. That'll be the plea cutoff. So I'm giving a little extra time here so that with the idea that if we don't have a plea at that next status conference, then we'll be going to trial on both files. So Mr. Roll, were you able to hear all of what we've said here today?
Yes, Your Honor.
Okay, so between now and the next hearing, which is going to be in about 60 days, you need to make sure that you stay in touch with your attorney, Mr. Trush. and that you come to that next hearing ready with a final decision about whether you want to accept any plea offers or go to trial, okay?
Yes, Your Honor.
Is there anything else we can address for this?
Not in regards to this file.
Mr. Roll?
There, thank you.
Mr. Roll, do you have any questions at all?
Maybe possibly about getting my stuff, the rest of my stuff from Victoria. But that would be about it. Maybe I could just talk to my attorney about that. I don't know how that would all work.
Yeah, so Chris, I'll be over at the jail probably in the next couple of days. I can talk to you about the process you can go through to get property back.
Okay, yeah, because I've already got some of it back, but she only gave me half of it back.
Yeah, we'll talk about the things that are available to you in terms of how you can do that.
Okay, all right.
Okay, thank you. That's all for today, Mr. Roll.
Thank you, Your Honor.
One thing I wanted to go back to, and this is on Mr. Butt's case, file number 246743. We entered a plea earlier this morning on that case. I did want to note that is set for trial, I believe, on April 1st. So in light of the plea today, the court will adjourn the trial date unless there's some objection.
That would seem a wholly appropriate way to
So
proceed.
no objection by the people, thank you, Judge.
Thank you. Our next hearing is set for 9:15. Mr. O'Neill, have you had any contact with Mr. O'Neill?
I did. I spoke with him last week. And I know he did make contact with the probation department about the PSI as well, so.
Not here yet?
No, sir.
All right, we're a couple minutes ahead of schedule, so we'll take a short recess and then we'll come back on the record.
All rise, please.
Back on the record, the court will call People versus Colby O'Neill, case number 246759. Mr. O'Neill here. Mr. Truth.
He is not, although the last communication that I got from him when we took a break, I did message him. He said he was about 10 minutes out, and that was 8 minutes ago. So perhaps if we address Mr. Rogers, Mr. O'Neill will be here.
Okay, Mr. Rogers, if you want to come up to the podium here, please. And we're on the record as People versus Terry Rogers. This is file number 246768. The record should reflect Mr. Rogers is present here in the courtroom today. Mr. Rogers, did you have a chance to go through the report with Mr. Trush, your attorney?
No.
You need time to do that with him here?
No, I read the report.
Okay.
Yeah.
You have the right to talk to your attorney about that. Do you want to do that?
No.
No. Okay. Mr. Trush, are there any corrections, additions, deletions?
No, Your Honor.
Are there any challenges to the scoring?
No, Your Honor.
Mr. Rolla, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocution?
Yes, Your Honor. This is a situation, the court is here. This is a case where after the facts were presented, the jury took all of 9 minutes to find the defendant guilty. It's a first felony situation, but not only was it defensive, completely offensive and obstructive police officers, but actually in this case, probably trying to help him because he had a piece of something hanging underneath his vehicle. And they wanted to make sure he could drive home safely, but for reasons that he only knows, he chose not to do that which the law requires him to do. In this particular case, there's a recommendation of fines and costs only. People understand that under the new Criminal Justice Reforms Acts, there's a presumption of no jail. As this defendant unnecessarily tied up and wasted a number of police officers who could have been handling other matters, including, by the way, supervising sergeant. We think at least a probationary period, in addition to fines and costs, should be imposed by the court. Perhaps to do otherwise sends the wrong message both to the public and to law enforcement. Thank you, Your Honor.
Thank you, Mr. Church.
Your Honor, Mr. Rogers has indicated to me that he intends to appeal his conviction. I guess what I would indicate to the court is, the sort of objective background here, I don't think supports anything other than what the recommendation is. That is to say, Mr. Rogers, 73 years old, has not had any interaction with law enforcement prior to this. Again, I think he disagrees about what his obligations are, whether or not he's required to identify himself in that situation under the law. He's entitled to that position. I think the jury made the finding that they did. I don't think that this is a situation where there was any sort of violence or anything like that. When the police wanted to arrest him, he willingly got out of the car, willingly put his hands together and was arrested. I don't think this is the type of situation that warrants anything more than fines and costs. Thank you.
Thank you. Anything you wanted to say today, sir?
Well, yes. I explained to the officers that I would take care of it, and being an expert, and they went from unsecured load to that I committed a crime, leaving the scene of an accident. And there was no accident, sir. And as the district attorney said, they asked me 14 times and they did not. And they asked me for my insurance and my registration, and they never did, sir. And both police officers lied here on stand. And you heard it. One officer said they took my wallet off of me. And the other officer said they took it out of my center console. Who is the crooks here? who is lying? It's certainly not me. And by not showing my ID, because these people are saying I committed a crime by the streets tearing up my car. And I examined it, and there was no danger to anybody at all. And I told them I'd fix it when I got home. And they went from unsecured load to I'm a criminal for leaving in the scene of an accident. Is ridiculous. And that's why I'm standing my ground. Because this whole thing is nonsense. And I'm not a criminal. And I would never leave the scene of an accident. I have no record. I've not been in trouble. And this whole thing is a farce. And that's what I think. And that's why I'm standing my ground. And I'm sorry for this whole thing. But I just can't abide by this, sir. I just can't.
Okay. All right, I read through the report.
Yes,
I presided over the trial, so I saw all the evidence.
yes.
And I'm familiar with your background and your circumstances based on the information in the report. And you're right, there's a lot of things that you have going for you here. You've never been in trouble before. And so someone who's made it as far as you have in life without having any problems tells me that you're generally a law-abiding person. And that throughout your life, you've been able to conform your behavior to what we all expect of law-abiding citizens. So you're right about that, and that certainly plays a factor in the court's decision about what an appropriate sentence is.
Thank you.
I think there's some things you're wrong about. I don't think the officers lied. I said here. No, I don't, because everything that happened was on videotape. So we all got to see it. So
You didn't.
hold on. Let me tell you something, okay? You had your trial. You got to speak. You got to speak here today. You told me your position.
Yes,
This isn't a debate.
okay,
We're not going to argue. Now it's my turn to talk.
okay,
So I haven't been able to talk yet.
yes,
So I'm going to tell you what I think. You told me what you think, and I've listened to it. I'm going to tell you what I think, and now you have to listen to me.
yes.
I don't think the officers lied because what happened is all on videotape. So if you think that, then I don't think you're looking at things the right way. I also think you're missing the point of this case, which is the law requires you to provide your identification, driver's license, insurance, and registration.
Yes.
And you didn't do that. And they gave you lots of chances to do that. So when you say you're standing your ground, you're incredibly mistaken. And I don't know where you get the idea that you don't have to show your driver's license. The law couldn't be clearer on that. I don't know what you've been looking at on the internet or what people have been telling you, but they're wrong. It took a jury of 12 people of your fellow citizens 9 minutes to find that you were guilty for not providing your driver's license. So the stuff about the accident and all that doesn't matter. What matters is you were required under the law to provide your license. You had plenty of chances to do that. You insulted the police officer, told him he didn't know what he was doing and maybe he needed to go back to school. Like, that to me is ridiculous because you're the one who's wrong on the law. And if you appeal this, I think you're going to continue to find that out because there really is no basis for you to appeal. You have the right to do that, and I encourage you to do it. But I think you're going to find up and down the line, everybody who knows anything about the law is going to be telling you that you were in the wrong. Maybe someday you're going to accept that. Maybe someday you're not. But the idea that you didn't have to show your driver's license is the most common sense thing. And it's just clearly required by the law. And so the fact that all this time has been wasted and all this inconvenience that I know you feel you've been put through didn't have to happen. You caused it all, every single bit of it. And so to blame any of this on the police officers or the system is just your failure to take any accountability for your own actions. Because if you would have just showed them your driver's license, you wouldn't be here right now. And if you would have complied with the law, you wouldn't be here right now. So to blame everybody else for what happened here is ridiculous from my standpoint, and just a complete lack of accountability on your part for following the law. And you had lots of chances to do it and you decided not to. And I think police officers did absolutely everything right throughout that circumstance. It gave you every chance that they could to do what you're supposed to do under the law. And you thought you knew better, and you don't. And I think it's unfortunate for you to get up here and claim that the police officers lied or that somehow everybody's set against you in this, when it's just not the case. I do think a period of oversight is appropriate here. I don't think jail time up front is appropriate. Number one, because you don't have any kind of prior record. Number two, now the law presumes that non-assaultive or violent offenses should not carry with them jail time. I also do feel, based on what I read in this report, that you've had some health issues that may have contributed to the way that you're viewing this. And I kind of your inability, I think, to see what you did wrong. And so I think some of your health issues are contributing to that. I think at a different time in your life, you might have viewed this whole situation a little bit differently. So I think all of that's contributing to it. So the court is going to place you on probation for a short period of time, 6 months. The court's going to adopt as the terms of that probation all the standard terms and conditions. The court is not going to impose any jail time up front, as I said. The court is going to order that you pay a crime victims assessment of $130, court costs of $325, attorney fees of $350, a DNA testing fee of $60, and a $68 state cost. You are entitled to 2 days of jail credit. And you do have the ability to, the right to seek an appeal of this sentence. And Mr. Trush, have you provided those rights to Mr.?
I have. I'm tendering the acknowledged copy.
So Mr. Rogers, those papers explain to you how to seek an appeal and how to request an attorney to help you with that. Ms. Davis, do you need anything else from me in terms of the conditions of the probation?
I don't think so.
Okay, so we're just going to ask you to meet with Ms. Davis here right after court, and she's going to help you with the terms of your probation.
Okay.
Mr. Roll, anything else that we need to address?
Is the court imposing an oversight fee?
Oh, I'm sorry. Yeah, Ms. Davis, if you can include that as well.
Thank you. Nothing for
Mr. Trush.
Nothing further.
All right, thank you. That's all for today. Good luck to you going forward, Mr. Rogers.
Thank you, sir.
Mr. Trush. Are you ready with Mr. O'Neill's case?
We are here.
Mr. O'Neill, do you want to come forward to the podium, please? Record should reflect Mr. O'Neill is present. Mr. O'Neill, your hearing was set at 9:15. Is there anything you'd like to share?
I'm sorry, Your Honor, I was on the floor this morning with my lungs. I was hacking up really bad. I had to throw it up, and it took me a little longer to get out the door than I expected.
Mr. Trush, I have here a report from the probation department indicating that Mr. O'Neill has not complied with the pre-sentence process.
So I think that's accurate. A PSI has been completed. He has been in contact with Mr. Bernico. I think they have a time set up. In terms of what happened here, Mr. O'Neill had a little bit of a tragedy happen. His significant other committed suicide, and frankly, I think it's understandable that he just kind of disconnected. He wasn't really prepared or willing to do anything at that stage.
Your Honor. Yes, that was a turmoil, but I'm a vehicleist. I just got a vehicle here last week.
Okay. So are you saying that wasn't the reason, or?
That's not the whole reason, no. Means of transportation were part of it, but that definitely rocked my world.
When did that occur?
3 weeks, 3.5. About 4 weeks ago.
Okay. All right.
Judge, it's unfortunate that has happened, obviously, it's a tragic situation, but it still doesn't explain why it took Mr. O'Neill all this time to not make earlier contact. We're gonna need to adjourn the sentencing anyway, because the PSI still needs to be. On record, Mike Walden.
Thank you. Ms. Davis, I did receive the report for Mr. Brunical. Was there any other information?
There was one update that he did have on there, that Mr. O'Neill contacted him on March 12th, stating that he was now available for the interview. But was advised that the report had already been submitted.
All right. Mr. O'Neill, I'm certainly sympathetic to your loss. That's terrible. And no one should have to go through that. So very sorry to hear that. Aside from that, though, most of these events here that are listed, failures to follow through occurred, frankly, before that. So that wouldn't be really a reason for you to not comply with the pre-sentence report. I have concerns based on, you being late here today. Things just have not gone well since you entered the plea. I think for the sake of getting this matter to sentencing, for the sake of making sure that you comply with the pre-sentence process, the court is going to revoke your bond, or it's going to order that you be taken into custody here today. Ms. Davis, if you can inform Mr. Brunical that Mr. O'Neill will be in jail, we'll have the report prepared. The court will set this for sentencing at the next available date. Look forward to that time. Mr. Roll, anything further on this?
Thank you,
Mr. Church.
I just asked court to set it at the next available date.
Okay, so Mr. O'Neill, I'm going to have to go with the officers.
Tell my ride that I won't be going.
The officers will help to take care of that. Mr. Deshane present?
Yes, Your Honor.
Deshane, if you'll come forward, please. Okay, Ms. Metowski, can you unmute for a second?
Good morning.
Good morning. You're here for the, I'm sorry, the Sean Deshane matter, is that correct?
Yes.
Okay, I'm just going to mute you for the moment. There'll be a point during the hearing when you have an opportunity to address the court, and I'll let you know when that time is, but otherwise you're free to remain connected until then, okay?
Okay, thank you.
And then, is it Miss Ange, or how do we pronounce your last name?
Carrie Angie.
Angie, okay. Miss Angie, you're here on behalf of the state, is that correct?
I am, Your Honor. Thank you.
Okay, so we're on the record in People versus Sean Deshane, file number 26723. Record should reflect Mr. Deshane's present here in the courtroom today. If I can have
Thank you, Your Honor. Richard Trush, appearing on behalf of Mr. Deshane.
Carrie Angie on behalf of the Attorney General's office.
Okay, this is the date and time set for a sentencing hearing in this matter. Mr. Deshane, have you had a chance to go through the pre-sentence report and talk to Mr. Church about that?
I have not, but I did hear about it briefly from my probation officer.
Okay, you have the right to have a chance to go through that with him before sentencing. Do you want to have a chance to do that this morning before we go forward?
I don't see how it'll change the outcome.
Okay.
So yes,
Well, you understand you do have the right, and I would take a break here for you to be able to go through that with Mr. Trush.
I will. I mean,
Well, I'm going to ask you some specific questions here. Do you understand that you have that right?
yes, sir.
Okay. Did you want to exercise that right?
Yes, sir.
Okay. All right, so Ms. Metelsky and Ms. Angie, I'm just going to ask that you remain on the line for a couple minutes. I'm going to give Mr. Deshane an opportunity to go through the PSI with his client. I'm going to keep you in this Zoom waiting room, but just on hold. And once we're ready, I'll bring you back in, okay?
Thank you, Your Honor.
We'll go off the record for about 10 minutes.
All rise, please.
right, we've got everybody back connected. We're back on the record at People versus Deshane. Mr. Deshane, had you had an adequate opportunity to go through that report with Mr. Trush?
Yes, Your Honor.
Mr. Trush, are there any additions, deletions, or corrections?
I know, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Mr. Rolla, do the people have any additions, or I'm sorry, Miss Angie, do the people have any additions, deletions, or corrections?
No, Your Honor, thank you.
And any challenges to the scoring of the guidelines?
No, Judge.
I know we do have Miss Metelsky. Miss Metelsky, if you can unmute at this time. Miss Metelsky, you do have the right to make a statement here today for purposes of sentencing. Did you want to make a statement?
If I could, yes, please.
Okay, and first of all, can you just tell me your first and last name and spell both for the record?
Megan Metelsky, MEGANMATELSKI.
Okay, and can you tell me your relationship to this case?
Sean and I have two children together. One is my daughter will be 20 and my son will be 18 in July.
All right, and the subject of this matter is a failure to pay child support, so you would have been the payee, in other words, the person who should have received the money on
Yes,
behalf of your children.
yes.
Okay, what is it that you would like to say here to the court today?
After almost 20 years, I just feel like disappointed, I guess. Our son, when he was born, he had a lot of medical issues we're still contending with, and he's going to be 17. That's cost like a lot of money over the years. And Sean has never, ever thought of like how much stress and how you can't go to work and anything to do with the child, I guess, at this point. Our daughter started college. She's actually graduating this year with her associate's degree. I'm helping her through college. My son plans to go to college next year. I mean, it's a lot of money and he just never has to pay anything, but it would be great if he could start helping pay back what he owes so I can help them and for their future.
All right, thank you. Was there anything else that you wanted the court to know today?
Nope, that'll do. Thank you.
Okay. All right, thank you. Miss Angie, anything on behalf of the people for allocution?
Just briefly, Your Honor, when this information was drafted, the arrears were $22,297.53. That was on October 6th of 2022. The arrears as of March 13th, which was Friday, are $25,467.62. So as you can see, the arrears have not only not gone down, but they've grown in excess of $3,000. The case charges at a measly $177 a month. Looking back over the payment records, I can see giant gaps where years went by without any kind of a payment whatsoever, which is discouraging enough on its face, but then to hear Miss Metelsky appear here this morning and describe the medical challenges that her son has had since his birth, it really becomes astounding that this defendant couldn't simply scrape together $177 a month to help her deal with those struggles and support his own children. The guidelines I see here are 10 to 34. I see that this defendant has 10 prior felonies and 9 prior misdemeanors, many of which are assaultive, many of which include breaking and entering buildings with intent. These are serious high-level felonies, and the guidelines of 10 to 34 somewhat speak to that, I think. Now, the recommendation is for a mere 2 years of probation with a 12-month jail sentence to be held in abeyance. I'm not certain that that's appropriate. It would be a different story if there was an income withholding notice that had been entered in this matter and the defendant had actually gotten a job during the pendency of this case and could tell the court, I have a job now and I'm paying toward these arrears. Now, he has made some payments of late. I certainly don't want to mislead the court. He made a payment, a couple payments in February, one payment in January, and then we're going back to October. like I said, it would be nice if there were an income withholding notice on file so that Ms. Metalski could be assured of some possible way to be paid money that she has paid to support her children for the past 18 years. So I'm not sure if the court wants to consider a jail sentence. Oh, and I forgot to add that there are current active warrants for this defendant's arrests on 2 other cases, and that he's on probation for other felony, other misdemeanors, and operating while intoxicated second, and fleeing and eluding the police when all this started to happen and as we speak. I think all of that's a pretty heavy load for this court to consider. And at this point, I think I would advocate for some time in jail in lieu of the 12 months in abeyance that probation is recommending. And I would ask for a jail term to be followed by 2 or 3 years of probation. Also, one final thing, I'd ask for the court to add into the conditions, probationary conditions, that restitution be paid in the amount of $25,467.62 at a reasonable monthly rate. Thank you.
All right, Mr. Church.
Thank you, Your Honor. First, I mean, as far as the restitution amount, again, I think it is listed in here. I think it is slightly less listed in the report than what's reported today. Obviously, whatever friend of the court determines that to be is what it is. We don't have any dispute of that. I would strongly advocate against imposing upfront jail here. I certainly can understand the prosecutor's position in terms of an income withholding. I don't know that that's feasible in the scenario where Mr. Deshano is self-employed. He does construction type work. He does remodeling in homes, tile work, that kind of stuff, flooring. It's not the type of business I think that an income withholding is likely practical. I think that the court certainly can monitor the payments and make sure they're there and use the jail held in abeyance as a metric to do that. But I also think the court, in looking at some of the history that's outlined here, I mean, Mr. Deshano will tell you he struggled with alcoholism for a very, very long time. And that bears out in the history. It's what he's on probation for. He's been sober since that time. He dealt with that case. He served some jail time there. And then when he got out, he started his business back up and he's started making money. He started making some payments and making some progress. Some of the payments aren't reflective of what they're indicating there because there's 2 different cases, and some of the payments got directed to other cases by friend of the court as opposed to this matter. But the fact of the matter is, since he got out and was placed on probation, he's been working, he's been making payments. I would caution the court, I think, well, I certainly can understand the position of some upfront jail. I think the practical effect of that is if you impose upfront jail, now when he's released from that in 30, 60 days, whatever the time is, he has to start to rebuild the business. He has to start to catch up bills. And inevitably what winds up happening, I think, is you wind up setting back the payment of getting the child support paid. The recommendation here that calls for holding the jail in abeyance really holds his feet to the fire. He has no excuse to not make the payments. He's telling you here today, he's employed, he's working, he's making money. There's no excuse for him not to do it. And I'd ask the court to give him the opportunity to show that. He's excelled at the probation that he's on right now. This is probably the longest period of sobriety he's had in his adult life, I would guess.
Yes.
He's doing well. And I would ask the court to give him a chance to continue to show that. Because at the end of the day, I mean, what we all want is for the child support to get paid and for it to go to the kids because that's where it's supposed to go. And for it to be used for their betterment. Again, Mr. Deshano's not going to stand here and defend the actions that he's taken in the past. He's not. He knows he wasn't doing what he was supposed to. But he's making efforts to do that, to do the right things now. And I think the court should take that into account. I would ask the court additionally to consider waiving the court-appointed attorney fee in this matter. Again, I would just rather see as much of the money as we can going to the arrearages and going to the kids.
All right, thank you. Mr. Deshano, anything you wanted to say?
Yes, Your Honor. I believe what Ms. Ann said is not completely accurate. I don't have one single violent crime on my record. So I believe that her statement gives misinformation to the court, and biasness already gets created before I even get to speak, in a sense, maybe, maybe not, but I have no violent crimes. I've never had any violent crimes. I have been making payments, and, okay, well, I want to tell you this. In 2010, because Ms. Metelsky and I tried to be a couple for years. In 2010, I got caught with 14 ounces of weed, and I went on the run. For 8 years, I was gone. I came back here on my own to turn myself in, to start this process. I spent a year and a half in jail, or more than a year in jail. Oh, no, I didn't. I got a year in jail. Then I got out, I was still drinking. I got another drunk driving. On December 20, or on New Year's Eve of 2023, I finally got sober. It took months for just my head to clear out, just for me to even care about responsibility. So, yeah, I guess I have screwed up a ton, but I'm not the person I was, and I can't fix it overnight. But I am sober. I am on felony probation. This stemmed before that. This was going on before that probation. So it's not like I got put on probation and got in trouble again. That's why I'm not being violated from probation, because this is before that. So all of these things are wreckage of my past, as we were talking about AA. And it takes time to fix it. Right now, I have some lady's house torn apart in Boyne Falls because all my tools at her house. If I can't complete that job, she could sue me. I'd lose all my stuff. So I can't make the money sitting in jail. And I have been making payments. In the past 90 days, I've paid on my other case and this case, thousands of dollars. I paid $1,000 1 month and then turned around and paid another, I forget, $513 in a 17-day period. On my other case, I paid $1,500 and some bucks, and then still made this child support obligation. And then I think the last thing I would like to say is that for Mrs. Ange to say that it was a measly $197, that wasn't what it was for all of these years. We have another daughter that Ms. Metelsky spoke about. My child support was $600. It wasn't $100. So I feel, and I understand that, or I feel like her words were slanderish. Not that I'm not guilty, but I think they were created to create some form of, I don't like the way that she spoke. I don't think that's fair, and I don't think that it displayed who I am today or who I was, because I don't have any violent crimes. I'm not a violent person. I was an alcoholic. I was now sober. And I just completed a full year of substance abuse counseling.
Okay. All right. So I did have a chance to review the pre-sentence report. I'm familiar with all the information in that report about your background, your history, and so forth. So I'm fully familiar with all of that. And I take all of that into account, along with certainly what Ms. Metelsky's had to say here today. I think she made some very poignant comments, which I'm going to address a little more in a second. What your attorneys had to say, what the prosecutors had to say, what you had to say. The reason why everybody gets to talk is because everybody views things a little differently. And I understand the prosecutor's position. You give me your side of it, I hear Ms. Metelsky's side of it. So everybody gets to give the court what their perspective on this is. These are always really difficult cases for the court to determine what an appropriate resolution is, because the goal here is to get the money paid and get it to the benefit of the children here, which is the whole point of this, going all the way back to the beginning. I can appreciate that you've had some issues in your life that you've been dealing with that have contributed to your problems overall with the law. And you do have got a lot of convictions, whether they're violent or not. You've gotten yourself into a lot of trouble over the years. Ms. Metelsky and your children have had to pay for that as well. When you're talking about your struggles and what you had to go through, she's trying to take care of these kids and do it on her own without any help from you. And if you think it's hard to do that on your own, I suspect it's a heck of a lot harder when you have 2 kids to worry about. So as tough as things were for you, it's hard for me to have any kind of sympathy for you when she's out there trying to raise 2 kids and do it on her own while you're off trying to avoid marijuana charges. So, you know, when you tell me about how difficult things have been for you, it's hard for me to have any sympathy because things were much more difficult on Ms. Witowski than they were for you because you only have to worry about yourself. I think, you know, again, it's difficult because what I want is for you to pay this money. I think that's probably what Ms. Witowski wants, to get it to the children so that they can have the benefit of that they haven't had throughout this time. But at the same time, you know, you have amassed quite a record. There's a really strong argument for you doing some time for this and paying some consequences. But I think this is the type of case where, and I get this argument, and I appreciate Mr. Trush's point, but it's always the argument of the defense attorney to keep him out of jail so he can pay, kind of thing. And I'm going to give you an opportunity to do that with the understanding that if you're not doing that, there really is absolutely no reason for the court not to have you incarcerated. So I am going to place you on probation. I think you should understand, and you probably do, that your guidelines call for up to almost 3 years in prison. And I can tell you that if you're not going to be paying on this child support, as I'm going to order you to as part of your probation, that and you're guilty of violating your probation for not paying, it's not going to be local time. You've been on probation 7 times. You've had 8 jail sentences. So it won't be local time. If you violate your probation and you don't pay on the support like you're supposed to, you'll be going to prison. Because there's no other reason for me not to do it right now, other than to give you one more chance to start making these payments. If you're not going to do that, then there's just absolutely no reason for you to not go to prison. So I hope that is a motivator for you to stay sober, to continue with your business, and to continue making payments, because there's going to be a significant consequence if you fail to do that. So the court is going to follow the recommendation to the extent that we're going to place you on probation for a period of 3 years. The court is going to adopt as the conditions of the probation all the terms and conditions that are listed in the report. The court is going to order restitution in the amount of $25,467.62. That's payable to the friend of the court, be dispersed to Megan Metelsky. That's in a monthly amount of $276.50, which breaks down to $177 of present obligation and $99.50 for arrears. The court is going to order a crime victims assessment of $130, court costs of $325, attorney fees of $350, and the $68 state cost. Because the court is ordering this as restitution, any amounts that are paid will go to the child support first before it goes to any of those other amounts that I've just mentioned. And so if at some point, you know, you're getting towards the end and the only thing that's stopping you from finishing your payments are the attorney fees, as Mr. Trush indicated, I certainly would consider waiving some of those fines and costs if it means that Ms. Metelsky is going to receive the full amount that's due. You do have the ability to, you have 38 days of jail credit. Now the court's going to hold any jail in abeyance at this time going forward. But you do currently have 38 days of credit. You do have the ability to seek an appeal of the sentence. And Mr. Trush, have you provided those appellate rights to Mr. Deshano?
I have.
Ms. Davis, you're not the supervising agent, it's be Mr. Brunical. Can you just let Mr. Brunical know that there's violations, we need to get those addressed immediately. There's no leeway on this case for Mr. Deshane. Miss Angie, anything further that we need to address for the record today?
Judge, I'm sorry, I didn't hear if you said 2 or 3 years of probation.
3.
Thank you. Nothing further.
Okay, Mr. Trish, anything further?
Nothing further, thank you.
And Ms. Davis, are you gonna talk to Mr. Deshane about making contact, with Mr. Brunical here
I
today?
am not agent for the county.
Okay, so make sure you follow up with Mr. Brunical.
You got my probation officer right
Okay. Okay, thank you. Good luck to you going forward.
Thank
That's
you,
all
Your
for
Honor.
this hearing. Miss Angie and Ms. Metowski, you're free to disconnect.
Thank you,
Thank
Your
you.
Honor.
Ron, are we ready with the department's case?
Yeah, sure.
Versus Hartman, this is file number 246752.
Larry Brown, on behalf of Mr. Hartman. He is not here.
Okay, 1 second.
I did not expect him to be here.
This was set for a status conference at 10 a.m. It is now 10:22. Brown and Mr. Hurt is not present. Brown, have you had any contact with him?
Your Honor, the last contact I had with Mr. Hartman was back on February the 11th. This matter was set for a trial, which is coming up on April 4th. I have 3 phone numbers on file. His phone, I believe, is disconnected. There's another phone number that I've left messages, have not received a reply. Third number was for his former boss, worked with seasonally, hasn't seen him since December. I did get on to Facebook as well, sent him some messages. They may have gone to a spam, sent him an email. I did see a Facebook post that he apparently made back on March 11th, looking for anybody to maybe give him a place to stay for a couple days. So my assumption is he's currently homeless. That is all the information that I have on Mr. Hartman at this time.
Mr. Rolla, do people take any position?
Yes, sure. As you recall, when we were back here in October, October had already authorized a bench warrant, and the defendant showed up some 15 minutes after his time period he was supposed to have been for his event. This is a repeated history, and I see we have a trial now scheduled for April 4th to be the people's position that a bench warrant should be issued. I need to report the decision as to whether or not we be.
All right. Based on Mr. Hartman's non-appearance here today and lack of contact with this council, based on his previous record here before the court in this file, court will request people draft a bench warrant for his arrest. Once he's arrested and brought before the court will schedule it for another status conference based on his failure to appear today, and to conserve the resources of parties, in particular the prosecutor's office, for subpoenaing witnesses and so forth. Court will adjourn the trial date, and the court will order that Mr. Hartman be held without bond once he is arrested, pending that next hearing. We'll reset the trial once he's in custody. And go from there. Mr. Rolla, anything further on that file?
Not in this matter, Your Honor. Thank you.
Mr. Brown?
No, Your Honor, thank you.
Yeah, Mr. Churchno, we're ready for Mr. Wall's case.
Yes, sir.
you still want me to put 12 months holding variance on that? No, just jail. Okay.
Just want to go search the back.
Okay, with Mr. James.
On that table.
Okay.
Yes.
All rise, please.
Seated.
Mr. Truce, are you ready with Mr. Ball's matter?
Yes, Your Honor.
Mr. Ball, if you want to come forward, to the podium, please, we'll go on record and People versus Eric Ball, number of files 6733, 6734, 6746, 6771, 6772, and 6788.
Record should reflect Mr. Ball is present here in the courtroom today. Like to have counsel for the defense.
Thank you, for the record, that's all, on behalf of people, there's all files.
Thank you, Your Honor. Richard Truce, appearing on behalf of Mr. Ball.
And we're here for a status conference in these cases along with the people's motion consolidate. Mr. Truce, are you opposing that motion?
We do, Your Honor.
Okay. I did have a chance to review Mr. Rola's brief in support of that. Mr. Truce, can you tell me what your objections?
So, I mean, I think the test that the court should go through is well outlined by the prosecutor. I mean, it's effectively, it has to be from the same transaction, right? I mean, we have to have the same transaction. In this case, I don't think that we have the same transaction at all. In fact, what we have is 6 separate independent transactions on different dates. The transactions are not all the same. So that the prosecutor sort of broadly classifies this as, it's restoring classic cars. I don't think that's the case at all. Throughout the 6 cases, there are some cases that involve restoring classic cars. There's some cases that just involve ordering parts, and there's some cases that involve doing routine work on cars. I mean, what we have here is Mr. Ball is running a mechanic shop. I mean, that's, I guess, the common thread that ties through these cases. He runs a mechanic shop. They're independent events. None of them are connected in any way. The witnesses, other than the officer in charge, Sergeant Crane, don't share the same witnesses. So again, I don't think that there is the criteria that would meet the requirements for joinder.
Thank you, Mr. Rolla.
All due respect to defense counsel, the witnesses are either the same state police officers or the same Gaylord City police officers involved in all the files. And this is not just a mechanic shop being run. This is a situation where the defendant has put himself out as an individual who restores expensive classic vehicles, roadsters, very expensive vehicles that, while it's true, some of them were just parts being replaced, but all of them are classic motor vehicles. All of them involve the same planner scheme as laid out in our brief, with the defendant putting himself out that he's going to do this restoration with taking extensive amounts of deposits for these, but never ordering the parts, never doing the work, or doing some minimal work and then leaving them out. And then more importantly, I guess that really ties all this together is the fact that when the owners, pursuant to the exact same agreement that the defendant has with all of the victims, and that's why they're different names, is that upon their demand in return, that cancels the contract and things have to be done. The defendant hasn't done that in any of these cases. What he did instead was keep the money, not order the parts, and move the vehicles from location to location to try and hide from getting caught. It's the same planner scheme. It's a simple situation. This defendant being a larcenous individual trying to take advantage of other people and keeping very, very large amounts of money while trying to avoid being caught. There is a plan and scheme, and I've laid that out in the courts, and the case law on this is very, very clear. All of them involve the same activities, and all of them, quite frankly, not just for the convenience of the court and the convenience for the witnesses, but as under 404B situation, it shows the defendant is acting in the same plan scheme to do this. All of these cases should be tried at the same time. Thank you.
Thank you, Mr. Truce. You wanted to say response?
I mean, I guess I would just say again, I don't think that they're factually the same. To suggest that all of these cars are classic cars is to pay a huge compliment to a Toyota RAV4. I mean, they're just not. Some of the cars surely are classic cars. Mr. Ball holds licensing as a master mechanic. He works on all types of vehicles. He does restorations. He does other work as well because he runs a mechanic shop. what the prosecutor classifies as moving the vehicles around. The mechanic shop closed. He sought to open another mechanic shop in Kalkaska County. He maintained contact with clients throughout that. I mean, I don't want to get too far into factual issues of what's going on in the case, but I mean, other than all of these people are from the mechanic shop that he runs, there's nothing that ties these cases together.
All right, thank you. As correctly cited, the rule that applies here is MCR 6.120. And specifically sub B, which provides for either on the court's own initiative or on the motion of the party, for the court to join offenses that are charged in 2 or more informations into a single information. Joinder is appropriate under B1 under 3 different potential circumstances. The same conduct or transaction, I think that clearly doesn't apply for the reasons that you stated, Mr. Trush. This is not one circumstance or one transaction, but that rule can also apply to a series of connected acts or a series of acts that constitute parts of a single plan or scheme. Court also needs to look at under sub 2 other factors, including the timeliness of the motion, the drain on the party's resources, the potential for confusion or prejudice stemming from either the number of charges or the complexity of the nature of the evidence, the potential for harassment, the convenience of witnesses, and the party's readiness for trial. In reviewing the motion and each of the separate informations, the court finds that there is, and again, this is discretionary with the court. The court is acting within the exercise of its discretion. The court finds that there is a basis to join all of these cases for trial under sub 1B or 1C, a series of connected acts or a series of acts constituting parts of a single scheme or plan, and in particular sub C, that last one I mentioned. I think an argument could be made that the facts show that Mr. Ball, if true and if proven, was operating this business and consistently taking money, not performing work, not installing parts, not returning vehicles. The allegations are similar enough in each of these informations. They all are separate transactions, but they all relate to the operation of a business with him as the proprietor of that business. Although each of the individual alleged victims may be independent witnesses, this was clearly a series of acts that were being investigated as a continuous pattern by law enforcement involving the same investigating officers. So the court finds there's sufficient evidence here to support finding that the allegations do constitute parts of a single scheme or plan. The court certainly would provide and does in cases of multiple charges, instruction to the jury, informing them that each of these are separate charges, that they have to consider each charge independently in light of all the evidence, and that they have to come to a verdict as to each separate charge on its own. And the court will give and does give that instruction frequently to juries involving multiple different charges. So the court finds that it's unlikely that any undue confusion or prejudice is going to result. Also, based on what I've been able to see from the evidence here, I don't find that this is a particularly complex case such that charging or trying all the charges together again would result in some type of undue confusion jury. And certainly there's sufficient time here that the court can build into the schedule to address parties in terms of readiness for trial. So for all those reasons, the court finds, again, in its discretion that there's a basis to join these pursuant to MCR 6.120. The court will grant the motion, and Mr. Bola, if you can prepare an order that reflects the ruling of the court today.
Well, thank you
on that. In terms of scheduling going forward in the status conference, Trush, I don't know if you had kind of thought of alternate tracks here depending on the court's ruling, but what's your view about how you'd like to proceed?
terms of scheduling?
We would be asking that it be scheduled for a trial.
Mr. Rolla, given the ruling of the court today, how many days of trial?
Probably at least 3 days, Judge.
Mr. Church?
I would think probably a half day or so for the defense presentation. So if the prosecutor is intending 3 full days, I would suggest we might need a 4th.
4 days. Okay, the court will set it for 4-day jury trial. Mr. Rolla, do the people need any particular period of time to be ready for trial?
60 days at most, Judge.
Mr. Church?
I would be comfortable with that time frame.
The court will set it about 90 days out. I will set this for a final status conference, which will be the plea and motion cutoff. So to the extent either side has any motions, they can be filed at the set for hearing no later than the date of the final status conference, which again will be the plea cutoff. Mr. Rolla, whether scheduling matters, the court can address.
Judge, I just indicate for the record, there was a plea offer that was set out. We will leave it open until the final status conference date. If it's not accepted by that time, it will be rejected and just proceed to trial. Thank you, Judge.
Mr. Church?
Nothing further.
Okay. All right, thank you. That's all for today.
Your Honor,
Yes.
he failed to appear for his delayed sentencing on 3/5/25 and a bench warrant was issued. He handled that bench warrant.
We did. I recall that based on circumstances. And I believe we're going to set that for another hearing. So. George?
Mr. George is here. I believe it's Mr. James.
Mr. Dash?
Or
Sir, is your name James Dash?
Yes.
Okay, let's take this case first since we're in video.
and he had indicated to me that Mr. Blumberg represents him, so I don't know if Mr. Blumberg is on Zoom, but he indicated to me he anticipated that Mr. Blumberg would be here.
Mr. Dash, I do not see Mr. Blumberg joining in. Are you saying he's going to appear on your behalf here today?
He was supposed to. I had to make some kind of call to him. Court was supposed to be at 1. Now it's 10:30. So maybe he wasn't anticipating it to be earlier.
Well,
So
this hearing's never been set for 1 o'clock. We just found out that you were arrested this morning, so we just set this
Thank
for an
you.
arraignment.
So I
Please get me out of
suspect
here.
that what may have happened is there may be a PPO violation and there might be separate charges as well. Because that would explain why he has an arraignment at the typical district court time.
All right. So we're here in this case on the PPO violation. So Mr. Dash, first of all, this is file number 2419632. The record should reflect that Mr. Dash is appearing today by video from Otsego County Jail. We have Mr. Trush here for purposes of arraignment, and then Mr. Roll is here on behalf of people. Mr. Dash, in this case, and I know I think you're gonna have another hearing on a different file relating to this later today. But the reason why you're before me here is for an alleged violation of a personal protection order involving Ms. DeGrasse. Do you understand that?
I understand. I don't think there's a valid PPO at the time, so.
Well, you may be able to have those kind of arguments. I just need to make sure that you understand why you're before the court here.
Okay. And then are you gonna be able to help me with my bail, my bonds amount for the other charge today? Cause the other one was like 25,000 and no 10%. And like, that's like, I'm not a flight risk by any means. Like, I've never done any wrong in my life. And I'm not a flight risk, so I don't know what we can do about to help me there.
Mr. Dash, the court is going to address your bond in this matter, but you have to address the bond in the other matter to the other judge when you're in front of him.
So I have to go in front of another judge?
Yeah, that's correct. You're gonna be arraigned in front of Judge Hesseling on the new criminal charges, probably at 1 o'clock. That's probably what you're thinking of for that. This is just relating to the personal protection order file.
Okay,
So you'll have a chance to ask Judge Hesseling during that arraignment to change that bond, but I don't have jurisdiction over that. I just have jurisdiction over this personal protection order case.
okay. Can you not put a bond on yours then, sir?
I'm-
Is there a
I'm gonna
bond
be-
on mine?
I'm gonna set a bond on this case, yeah. But we're not at that point yet because I need to go through some things with you with regard to your rights, okay?
Okay, I don't feel comfortable without speaking without Elliot present.
All right, well, I need to conduct an arraignment so I can enter a not guilty plea on your behalf. If you want to have Mr. Blumberg address bond in this case at some point, then he can file a motion to address bond. But we have an attorney here in case you need to talk to him. But otherwise, I'm going to go forward with the arraignment, okay?
Okay, I mean, no one's called him because he was supposed to be on my side. He's supposed to be here this morning.
Well, he's not. So I'm going forward one way or the other.
Okay, sir.
If you want to speak to the court-appointed attorney, I would certainly give you an opportunity to do that before we go forward with this hearing. But if you're saying that you've got Mr. Blumberg, he's not present, and I'm going to go forward.
Yeah, I mean, that's what I'm saying, is Mr. Blumberg's supposed to be present this morning.
So do you want to speak to the court-appointed attorney?
Outside of this hearing, or how do I speak to him?
About this hearing, we can take a break and I can put you in a breakout room so you can talk to him privately before we continue with this hearing.
I would like to, because I don't feel comfortable without my attorney.
Do you have the ability to do that, Mr. Church?
Yes.
What are we going to be doing on Mr. Jordan's case?
I anticipate that we are going to be making an admission.
Hopefully.
Yeah.
Okay, so we'll hold off on that for now. I'm going to have you talk to Mr. Dash.
Thank you.
So Mr. Dash, just 1 second, and I'm going to put you in a breakout room with Mr. Trush, who's the court-appointed attorney, so you can at least speak with an attorney this morning, okay?
Thank you.
I'm gonna go down the hall.
Oh.
So is he coming in this room now, or?
They put both of you and Todd, you're just talking to the two of you.
On this thing? I just need to get a hold of Elliot. Can I make?
All right, Mr. Dash, I'm going to put you into a breakout room so you can have a private conversation with the lawyer right now, all right?
All right, thank you, sir.
Okay, Mr. Carey, are you able to hear me all right?
Your Honor,
Mr. Majestic, are you able to hear me?
I am, Your Honor.
Okay, we're on the record now in Northern Mutual Insurance Company versus Prather and Bremen. This is case number 2419867. If I could have both counsel put your appearances on, please.
Casey Majestic for the plaintiff, Northern Mutual.
Your Honor, my name is William Carey, and I appear on behalf of the Prathers in this matter.
This was set for a hearing on plaintiff's motion for summary disposition. Was set for hearing at 10:45. It's now 10:51. I know Mr. Riemann is aware of this motion because he filed a responsive brief, but he is not present. But we're going to move forward since we're well past the time. Mr. Majestic, this is your motion. I guess one of the questions I had, in relation to your motion is viewing your complaint. All your claims are pled against the Prathers. I get why you would have named Mr. Riemann, I guess, as a defendant, but you didn't seek any specific relief as it relates to Mr. Riemann in your complaint. And so, from a procedural standpoint, and Mr. Riemann hasn't filed any claims against Northern Mutual asserting that he has any rights with regard to the policy. So, and understanding that this is a declaratory action, you address that for me a little bit. I guess I'm at a loss as to what I would be dismissing since there isn't any claims by Mr. Riemann here. And you haven't pled any claims against him. So do you see where I'm going with that? Can you address that from a procedural standpoint for me?
I do, Your Honor. All we're asking is a declaration that the policy doesn't relate to Mr. Riemann. If you look at the statute, it's pretty clear that the only way you can potentially get there would be under some sort of.
I'm gonna have you hold on for 1 second because I think Mr. Riemann's joining in now. Mr. Riemann, if you're there, we need you to turn on your microphone at least.
Can you hear me now, Judge?
I can, yep. We just got started with the hearing. I waited 6 minutes for you to connect. So we just got started. Mr. Majestic was just beginning his argument. So Mr. Majestic, the record should reflect Mr. Riemann's now connected. Mr. Majestic, if you can, I know you didn't get very far into it, but if you can start over from where you began, please.
Your Honor, you had asked me to indicate why Mr. Riemann's in the case, and we had filed suit against Mr. Riemann for a declaration that the policy didn't apply to him under any circumstances. We don't think it does. The only way that he could potentially be here would be as an intended third-party beneficiary. We don't believe as an intended third-party beneficiary. He wasn't a party to the contract. The contract wasn't entered into to benefit him. This isn't that type of situation. Courts have pretty uniformly held that potential payees of an insurance contract in Michigan are not intended third-party beneficiaries. They're incidental third-party beneficiaries as well.
I traded my cereal bars. Oh.
Well, sorry, someone else.
Go ahead.
Okay.
Go ahead.
We think the statute's pretty clear that if there ever was a circumstance in which Mr. Riemann could be even considered a third-party beneficiary, that isn't right. If you're looking at 600-1405B or 2B, it specifically indicates that the promise can be discharged by agreement between the promisor and the promisee prior to it vesting. That's likely what happened here. We don't think it vested. The policy is very clear on that as well as to when vesting could potentially occur. The policy indicates that there has to be a judgment against an insured for a covered loss or there has to be a liability established by a written agreement between the claimant, the insured, and us, which is three parties. That hasn't occurred. If you look at 1405 2C as well, it specifically indicates the promisee made by mutual agreement divest said person of its choice. This is done without intent to hinder, delay, or defraud said person in collection or enforcement of the said debt or other obligation. There's clearly a situation here in which any obligation that we might ever have is being discharged by our settlement with the Prathers. That's the end of the story. Mr. Ryman's neither an intended third-party beneficiary or his rights as any sort of a third-party beneficiary have never vested. He was divested of those prior to today's date.
All right, thank you. Mr. Freeman, I did have a chance to review your reply brief. Is there anything that you wanted to say today?
Yes, Your Honor, and apologize to you both for my difficulty here with the internet. I can't tell if you have audio or video, but you can hear me?
I can hear you fine, yes. I can't see you, but that's okay. But you're coming through audio.
Great, thank you, Your Honor. So, Judge, when I got this motion, I fully expected to lose it, and I was prepared to accept Mr. Majestic's initial motion, but I went through the work to read the cases, and that referred me to the place in the policy to look at, and I looked at it, and lo and behold, this policy language has the exact language that is referred to in all the cases that there is coverage. It specifically states, as I put in my brief, quote, may recover under this policy in referring to someone in my situation. I can recover under the policy. I was very surprised to find it. So I filed my brief, and Mr. Majestic then changed strategies. He went from, okay, Mr. Reman's not a third-party beneficiary, specifically named in this policy, to the new position that, well, we settled and we got rid of this claim before it vested. So that's where we are now. And Judge, there's more shenanigans going on. I'm not saying Mr. Majestic, but behind the scenes with the Prathers, they have settled with Mr. Majestic. They've also settled with me, but now they're trying to back out of that settlement and keep the funds for themselves. That's exactly what MCL 600.1405 2B speaks to. Mr. Majestic highlighted 2A and 2C, but 2B recognizes that for a third-party beneficiary, the vesting is a different point in time from when the policy is binding on the insurance company. For the insured, it vests at the time the contract is entered into. That's when it's binding on the insurance company. For a third-party beneficiary, 2B speaks to a situation where at the time the policy is binding on Northern, which is when it is entered into, third-party beneficiaries might not be known at that time. That's me. And so this says that the claim vests in the third-party beneficiary, 2B says, at the point in time he's identifiable. And that means the insured and their insurance company can amend their contract, cancel it. They can do whatever they want until there's a claim of a third-party beneficiary. And at that point, it's locked in. Now they can't try to freeze out the third-party beneficiary, so to speak. I can be identified. I filed a suit. I might get a settlement or a judgment, and therefore they can't work around me. They can't cancel it or pay my losses to their insured, which is what's happening right now. Now, Judge, I just put out in the mail and set for hearing on April 7th, the motion to enforce the settlement. It's a written settlement through emails with Mr. Carey. I know they disagree that it was binding, but we think under the case law that I've cited in my motion, it is. But in any event, once this claim is filed under the third-party statute, it's too late for the insurance company and their policyholder to try to change it to get around the claim. So we'd ask the court to deny the motion and actually enter under the court rules 2.119, enter summary judgment in favor of defendant Riemann, finding that there is coverage for the claims. Thank you, Judge.
All right, thank you. And Mr. Carey, I'll give you a chance to weigh in here in a minute, but Mr. Majestic, anything that you wanted to say in response to Mr. Riemann's argument?
Yeah, I did cite 2B and 2C, Your Honor, not 2A and 2C. I mean, 2B is pretty clear. It's the entirety of the provision is, if such person is not in being or ascertainable at the time the promise becomes legally binding on the promisor, then his rights shall become vested the moment he comes into being or becomes ascertainable. If the promise has not been discharged by agreement between the promisor and the promisee in the meantime, he's not vested. This has been discharged. The policy itself under liability coverage specifically states when he might come into being, and that would be when a judgment's entered against the praetors, and or if there's some sort of an agreement that he's entitled to recover. That hasn't happened yet. And if it does happen, it doesn't really matter because he's not an intended third-party beneficiary. He has to be an intended third-party beneficiary. This contract was entered into between Northern Mutual and the praetors to benefit Northern Mutual and the praetors. He's simply an incidental third-party beneficiary. Although he might get some sort of benefit down the line, they didn't enter into this contract to benefit him. I mean, I think a classic example of when a third-party beneficiary is intended would be if, say, I hire a mechanic to fix up a car for my son that's going to college. I specifically indicate that it's my son, he's in the contract, it's his car. He might be able to sue to enforce that promise. That isn't what happened here. This is pretty close to the Schmalfeld case, which was about a bar fight in which one of the patrons tried to sue the insurer of a bar. And even though they might be the payee under the contract at some point down the line, that contract wasn't entered into for their benefit. It was for the benefit of the insurance company and the insured. I mean, it takes the burden of paying these claims off the insured to do it this way. That's why it's done this way. Doesn't mean that they're an intended third-party beneficiary, Your Honor.
All right, thank you, Mr. Carey. Anything you wanted to state to weigh in?
Two things. We're here today to support the motion. Praetors have reached an agreement that's conditional upon the granting of this motion, reached a settlement agreement with Northern Mutual. And then while I don't think it's particularly relevant to this hearing, I don't want silence on my part to be misconstrued. We do not have a settlement agreement of any kind with Mr. Ryman. And in fact, we do not have a settlement. I'll be, I guess, more careful with my words. We do not have a settlement agreement in place with Mr. Ryman at all.
Okay. All right, thank you. So I did have a chance to review the motion. I had a chance to review Mr. Riemann's response and then the reply filed by the plaintiff on Northern Mutual. And I'm not gonna address whether or not there's any settlement agreement between the praetors and Mr. Riemann. That's something it sounds like will be for a separate day, and I appreciate counsel wanting to state that for the record in light of Mr. Riemann's comments, but I don't find that either way to be particularly relevant to this motion. I still, and Mr. Majestic, you really didn't address it. I still feel like there's a procedural issue here, which is the plaintiff, Northern Mutual, didn't plead any claims specifically as to Mr. Riemann. Mr. Riemann hasn't filed any claims against Northern Mutual asserting any rights under the policy yet. Doesn't mean he wouldn't or might not. So there isn't a claim by Mr. Riemann for Northern Mutual to get summary disposition of. There really isn't a claim by Northern Mutual against Mr. Riemann that the court could grant summary disposition on. I feel like this is really not a matter that's necessarily even in controversy at this point. And Northern Mutual has raised this as, to me, it feels like an anticipatory type thing where if Mr. Riemann wants to assert rights as a third-party beneficiary, that the court should right now say, if he does that, he's precluded from doing that as a matter of law. So to me, this really is more of a procedural issue than it is a substantive issue. And then looking at the part of the insurance policy that Mr. Riemann cited, which is the liability coverage, and the language of that is a person who has secured a judgment against an insured for a covered loss or has liability established by agreement between the claimant, and insured, and the insurance company is entitled to recover under this policy to the extent of coverage provided. I think both counsel, Mr. Riemann and Mr. Majestic, acknowledge that that's something that hasn't even come into play yet, because there haven't been any decision, certainly by this court, in the underlying case between Mr. Riemann and the Prathers. So, in my view, this is really a solution without a problem, or the plaintiffs are seeking a solution without a problem. I think really for Northern Mutual to get summary disposition of any type of claim by Mr. Riemann, he first needs to make some type of claim against Northern Mutual. And again, even though this is couched as a declaratory action, I think what Northern Mutual really is asking for here is some type of advisory ruling by the court about Mr. Riemann and his potential claims against Northern Mutual. So for all those reasons, I don't find that summary disposition is appropriate, because I don't find that there's an actual controversy as to Mr. Riemann as it relates to any rights he might have in the Prathers policy with Northern Mutual. So Mr. Majestic, I mean, it sounds like Northern Mutual has settled with the Prathers. In my view, that's really the end of this lawsuit. I don't even think Northern Mutual needs to get summary disposition of Mr. Riemann. They can just dismiss him and end this case if they've settled with the Prathers. And then I think it's on Mr. Riemann, if he believes he's got a claim against Northern Mutual, to file a lawsuit asserting that he has rights in the underlying insurance policy and what those rights are. And then I think, Mr. Majestic, your client may have an argument that he's not entitled to any interest under the policy for some of the reasons you stated today. But again, without any specific claims by Mr. Riemann in that policy, we don't know what language he might be relying on or what theories he might be relying on. So again, the court's denying the motion, not on the merits. In other words, I'm not ruling today whether or not Mr. Riemann is or isn't an intended third-party beneficiary or incidental third-party beneficiary, or maybe entitled to recover under the liability coverages clause. Again, I'm finding there just simply this isn't a matter that's in controversy at this time. So the way I would phrase it, Mr. Majestic, for purposes of an order coming out of this hearing, is the court's denying the motion on procedural grounds, not on the merits, and without prejudice. And if you can prepare an order that reflects that language and submit that under the 7-day rule, and then it sounds like we'll go forward with further proceedings in the underlying case in April based on Mr. Riemann's motion. And then Mr. Majestic, I guess the ball's in your court based on what I've indicated here on the record today to decide how your client, as the plaintiff in this file, wants to proceed in terms of closing that file.
Okay, thank you, Your Honor. I'll submit the order.
All right.
Yeah,
so,
thank you, gentlemen. Your Honor?
Yes.
If I may address the court and counsel. Mr. Riemann has indicated that he's secured a date in the underlying case for April 7th. I've addressed this issue with Mr. Riemann. I think we probably just didn't agree. That matter, the underlying matter, the liability claims by Riemann against Prather, is stayed pending the resolution of this deck action. And for reasons that are even more obvious today than they were before, this deck action needs a resolution prior to us going back to the underlying claims of Ryman versus Prather. I don't think the date, I don't think a motion date should have been provided to Mr. Ryman in light of the order of stay.
Well, I think that's an argument, Mr. Carey, that you have to make at that hearing. You know, and it's not something I'm certainly going to rule on here today because it's not part of what we have noticed up for today, but it sounds like, I mean, it does sound like this case is, if your client's settled with the insurance company, you know, I don't know what else there's left, as I've just indicated to Mr. Majestic, but that's an argument that I'm going to ask, I guess, that you make in April, and we'll go from there.
Fair enough.
Okay, I have to move on with my docket. So that is all for this file. Thank you. All parties on this case are free to disconnect at this time.
Thank you.
Thank you, Your Honor.
Thank you, Judge. I apologize for being late.
No problem. Thanks. All right, Mr. Dash, are you able to hear me?
Yeah.
Okay, we're back on the record in People versus James Dash. Mr. Truce, did you have a chance to speak to Mr. Dash on this file?
I did, Your Honor.
All right, Mr. Dash. So again, I'm going to go back to where we were, which is I need to go through your rights with you. You do have the right to have a hearing as to whether or not you did violate the personal protection order as alleged. You also have the right to have an attorney present at any subsequent proceedings. If Mr. Blumberg isn't going to represent you or you can't afford an attorney, one would be appointed for you at public expense. If you are found guilty of violating the personal protection order, the maximum possible penalty you could face would be up to 93 days in jail and or a $1,000 fine. Do you understand all those things that I've stated to you?
Yes, sir.
All right. And did you wish to enter a not guilty plea today?
Yes, sir.
All right, so the court will enter a not guilty plea on behalf of Mr. Dash with regard to the alleged violation. In terms of bond, Mr. Rolla, do the people take any position on bond on the PPO violation?
Just a couple things, if I may, Your Honor, indicate for the record. There's been some comments in the record that the defendant indicated he didn't believe there was a personal protection order. The purpose of this arraignment, I'd ask the court to look at its own file and acknowledge the existence of the PPO, case number 24-19632-TP, which proof of service is also in the file indicating that the defendant was personally served with a copy of that order on March 19th, 2024. So the fact that he's saying it doesn't exist does cause the people some concern as to whether or not the defendant's going to follow the orders of this court without some further restrictions. And again, it has also indicated on the record, should be noted, the defendant is looking at being arraigned later today, apparently on, I guess, home invasion, third charges, domestic violence charges, etc. But I'll leave that to Judge Hesselink later this afternoon. Thank you.
All right. Does Mr. Dash want you to speak on his behalf?
I am prepared to make a bond argument.
Okay, go ahead, please.
Your Honor, in regards to bond, he has a local address. He owns a local business here, Dash Electric. He has strong connections to the community. He's lived here over 10 years. Reports to me that he has 0 prior felonies, 0 prior misdemeanors. I would suggest to the court that a low bond is appropriate given his strong connections to the community, his lack of prior history, and the nature of this offense being a 93-day misdemeanor. I would suggest for the court a $3,000 10% would likely be appropriate given those circumstances and the facts before this court.
All right, I do find that to be an appropriate bond to secure Mr. Dash's appearance and further compliance with the order. So the court will set bond in the amount of $3,000, 10%. Mr. Dash, as far as I'm concerned, that personal protection order is still in place. You're free to make, when we have a hearing, if we get to that point, to make arguments that it wasn't valid for whatever reason you have for that argument. But as far as I'm concerned right now, until the court finds that it's not valid, it is a valid order, and you are not to have any contact with Mr. Grez. Do you have any questions about that?
No, Your Honor, thank you for your time and I appreciate you.
Okay, the court will set this for, and Mr. Dash, at this point, you're still indicating that Mr. Blumberg's going to represent you in this case?
Yeah, I would assume so. I just couldn't get a hold of him this morning. It's kind of been a rough go the last 3 days on communication outside of this place.
Okay, so again, if at some point you do wish to request a court-appointed attorney, you need to file that request with the court. But until then, the court is going to assume that you're going to retain your own counsel. The court will set this for a hearing on its next motion day, and you'll be provided with notice of the date and time of that hearing. That's all for today.
Thank you, Your Honor. Thank you, Your Honor.
Thank you. Are you ready with Mr. George's case?
Yes, Your Honor.
People versus Damian Lee George, file number 256789. Mr. George, can you come up to the podium, please? Reflect Mr. President in the courtroom today. We have counsel for your appearance.
Let's take the record, my phone, the people.
Thank you, Your Honor. Richard Church, on behalf of Mr. George.
Okay. And Mr. Treese, you indicated that we did have a resolution of this file today, is that correct?
We do, Your Honor. I received an offer from the prosecutor whereby Mr. George admitted to an added count 2 possession of a loaded firearm upon a motor vehicle, MCL 750227C. The principal charge would be dismissed, and that's a 2-year high court misdemeanor. And we'll be asking the court to take the factual basis to the higher charge and apply it to the lower.
Thank you. Mr. Rolla, is that a correct statement of the plea offer?
It is, and of course, as a matter of law, the gun has been confiscated pursuant to MCL 75239.
That is correct.
Mr. George, have you had an opportunity to speak with Mr. Trush about this plea agreement?
Yes, Your Honor.
And is that how you wanted to proceed today?
Yes, Your Honor.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
I do, Your Honor.
Thank you. You can lower your hand. Mr. George, are you currently on any kind of probation or parole?
No, sir.
And you understand that the maximum possible penalty you can face for this added count 2 would be up to 2 years?
Yes, Your Honor.
With that in mind, what is your plea to that charge today?
Guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights.
Yes, Your Honor.
And you understand that by pleading guilty, you're going to be giving up and waiving all of those rights, including the right to have a trial.
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
Your Honor.
Has anyone promised you anything other than what we said here in court today?
No, Your Honor.
Is it your own free choice to plead guilty?
Yes, Your Honor.
Are you pleading guilty because you are guilty?
Yes, Your Honor.
This happened back on November 5th of 2024. Is that the correct date?
Somewhere around that time. I'm not to be exact.
Okay. Sometime in early November of 2024. That sounds right.
Yes, Your Honor.
Okay. And at that time, were you present here in Otsego County?
Yes, Your Honor.
And did you have possession at some point of a firearm during that period of time?
Yes, Your Honor.
And had you previously been convicted of a felony that prevented you from possessing any firearms?
Your Honor, if I may assist.
Sure. Go ahead.
So you were present in Otsego County in early November
Yes, Your Honor.
of 2024. And at that time, were you an acquaintance of Isaac Day?
We know each other.
And did you permit Isaac Day to have your firearm?
Yes, Your Honor.
And at the time you did that, did you know that he had been to prison?
I knew he was recently out. Yeah.
So you knew he was a felon?
Yes.
And did he ever show you anything that would suggest he had taken steps to restore his firearms rights?
No.
I think that would satisfy the factual basis.
I think it's also good venue in there, Judge, we're good.
He did testify it was in Otsego.
Okay, I just want to make sure we're good there.
Okay.
So thank you. Yes, Judge, people have to feel the court has sufficient factual basis to accept pursuant to the court rule as a lesser included offense, the added count.
Are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor, thank you.
Mr. Truce, are you?
I'm satisfied there is a factual basis and I'm aware of no threats, promises, or inducements.
Mr. Rolla, as to that last issue?
People agree, yes.
Okay. Are you satisfied that the court has complied with statute and court rule and
Yes, Your Honor.
Mr. Truce?
I'm satisfied as well.
Mr. George, the court finds that your plea is knowing, voluntary, accurate. The court is satisfied there's a factual basis to support a finding that you are guilty of this added count 2. Court will accept your guilty plea. You're going to meet with Ms. Davis before you leave today to set up a pre-sentence interview. And then the court will set this for a sentencing hearing. You'll be notified of the date and time of that hearing. Between now and then, it's important for you to stay in touch with Mr. Truce. Do you have any questions at all? No. Yes. All right. Okay. Thank you. One more hearing that I need to do. That's the Zoom hearing. I'm gonna take a quick recess.
All right.
Okay, looks like we have council connected, so we'll go on the record. This is Randall versus
RG case number 1415291. If I could have both counsel put your appearances on.
Jody Doak on behalf of and Julia Brando.
And Danielski on behalf of Mr. Bargy.
Thank you. We're on the record today for hearing regarding an order coming out of the court's opinion. I did have a chance to look at the submissions of counsel. Mr. Danielski, anything that you wanted to state in support of your motion?
I think we resolved it, Your Honor. It was really about the transportation. Ms. Doak and I sent over an order this morning signed by me that resolves the issue.
Okay,
I
Ms.
believe
Doak.
she sent it to your
Sorry.
secretary. I believe she emailed it to your secretary, Your Honor.
Yeah, I drafted an order after speaking with Mr. Danielski. My office sent that over to your office this morning, Your Honor. And your assistant advised us to get on the record and let you know that that was on your desk. That would resolve the issue.
Okay, yep, I've been on the record all morning, so I haven't had a chance to see that, but I appreciate counsel working towards a resolution. I'll sign that order once I get a chance here, and all parties are free to disconnect. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
All right, that does conclude the court's morning docket. The court will be in recess until 1:30.